Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have 3 cases on for argument this morning. The first case is 24-2161, Cherry Grove Beach Gear LLC versus City of North Myrtle Beach. Mr. Moss?
Yes.
Whenever you're ready.
Good morning and thank you. It pleased the court. I wanted to briefly summarize the way that we outlined our arguments. I want to touch on the market participation exception to state action immunity and invite the Fourth Circuit to adopt that doctrine. I know that it was first suggested by the Supreme Court in dicta, but some of the circuits have adopted it, notably the 11th Circuit. I then want to look at the analysis of the lower court in the state action immunity issue and suggest to the court why we believe the analysis was flawed and should be revisited. And then finally, I want to touch on some of the other claims that were brought in the lower court on the contract clause claim and the taking claim under the Fifth Amendment, because we believe that the court's analysis under the state action immunity, having been flawed, that the analysis applied to the taking claim and the contract claim was not proper. And we believe that they have to be revisited in light of, the corrected legal doctrine. And so let's talk for a moment about market participant exception to state action immunity. The purpose of state action immunity was clearly set forth in that 1940 opinion in Parker versus Brown. And the doctrine is grounded in principles of federalism, and it was designed to respect the states and their governmental capacity as sovereign regulators. It was all about regulation. Nothing in that 1940 opinion had anything to do with market participation. Indeed, it was clear from the opinion that it was all regulation. Market participant conduct, though, in other words, engaging in private enterprise by a governmental entity, is not an integral part of traditional governmental functions. This conduct, this market participant conduct, does not fall within traditional Parker v. Brown state action immunity principles.
Tell me what about Western Star, this circuit's opinion in the Western Star case in 2021? Why should we recognize the market participant exception here when we did not, we refused to do so in the Western Star case in 2021?
Well, in Western Star, respectfully, I think the court got it exactly right, and the Virginia state statutes specifically authorized the conduct that was being undertaken and the anti-competitive nature of the conduct. In Western Star, right here in Richmond, the franchise agreements were state regulatory statute allowed the prohibition of operation of EMS vehicles in the jurisdiction without a permit. They permitted the jurisdiction to limit the number of permits issued for ambulances in the jurisdiction, and they also allowed the jurisdiction to set the fees that ambulances would charge. Those are very specific and clear articulation of a state policy to displace competition in that business.
So so it's your position that under the South Carolina Code 57145, it is not specific enough?
That's absolutely my position. I think any reading of 57145, they tell us the best indication of what a legislature intended is what statute says. And in 57145, there is the word.
Section 3. What about Section 3 under 57145.3?
Let me grab my copy. Under Section 3, it clearly says, well, Section 3 is not the starting place of the analysis, but under Section 3, it does say the municipality may grant an exclusive right to the beach safety company to rent only the beach equipment and to sell only the items to the public on the beach that are allowed. But you can't start the analysis with Section 3. You have to start the analysis with Section 1 under Section B of 57145. And it says, if the municipality contracts with a private beach safety company and they follow the lawful procurement policies either by the state or under city procurement code, and they grant a contract to a private beach safety company to provide those public safety services, lifeguards, then in that instance, they can grant an exclusive franchise to the private beach safety company. Nothing about that analysis includes the jurisdiction itself engaging in the monopolistic conduct. There's two roads they can take under 57145. They can provide those lifeguards and they can implement public safety regulations and enforce them. They can provide the lifeguards through the city staff, or they can hire a private beach safety company. 57145, sorry?
I'm sorry to interrupt you. This is Judge Diaz here. A couple of questions for you. First, back to your principal point about market participation, just so that I understand what your position is. You're not suggesting that there's a blanket prohibition on jurisdictions engaging in what would otherwise be proprietary market functions. But if I understood you correctly, you're saying that that authority has to be explicit before that activity can be undertaken. Do I have that right?
Yes, you do, Judge. And as a matter of fact,
Okay, so if we were to disagree with you that the statutes were in fact explicit enough, you would lose. I understand that's not your position, but if we think the statutes are sufficiently explicit to grant authority to the municipalities to do this very act of engaging in beach activities with regard to lifeguards and chairs and the like, then you would lose on appeal.
at least in this court, that is correct.
Okay. Well, I guess there is another court, but okay.
But our position clearly is that the monopoly legislated by North Myrtle Beach in 2022 is most certainly not the inherent logical or ordinary result of the exercise of authority granted in 57145.
Okay, now with respect to these statutes, why isn't it reasonable to read it, I think, as the district court did, as indicating a choice for the municipality in the state? That is, if the state or municipality in this instance chooses to grant a franchise, it may do so exclusively. But I don't, why is it that you're reading the statute to suggest a single proposition? Why isn't it either or? The state or municipality can grant a franchise if it chooses to do so, but if it doesn't, it can itself engage in this activity. Why isn't that a reasonable reading of the statute?
Well, with all due respect, I don't think it's a reasonable reading in the statute because the case law from the United States Supreme Court dictates otherwise. And if you look at the Town of Halley versus City of Eau Claire case, it's clear that the express words don't have to be included in the statute. You have to have a finding that there's some inherent logical or ordinary result of the exercise of the authority delegated in the statute. We know that from the Town of Halley case. But fast forward to 2013 and look at what happened in the Phoebe Putney case. That was a unanimous decision of the United States Supreme Court. In that decision, there was an express empowerment of those counties and municipalities to create hospital authorities. And there were 27 specific delegated authorities those authorities were given. And some of those authorities included the right to purchase land and to purchase hospitals and to purchase, they called them projects, but projects were defined to include hospitals and medical facilities, okay? So we had an express authorization in the statute that you can do these things. This is authority. But when challenged, the Supreme Court of the United States determined that's not enough. That's not enough to pass the clear articulation test. In that court, they determined that a general grant of authority was not enough. You have to have an explicit grant to compete in anti-competitive ways. In the Phoebe Putney case, it was Justice Sotomayor opinion. She actually stated in the opinion that you have to exercise your authority against the backdrop of federal antitrust laws. Now, in the lower court's opinion here, the lower court said that it was going to refuse to impose atextual limitations upon the city of North Myrtle Beach's power under 57145. But that's disregarding and disrespectful of the Supreme Court's Phoebe Putnam opinion, because I suggest to you that the backdrop of federal antitrust laws is just as Sotomayor wrote. The general powers have to be wielded in respect of the backdrop of the federal antitrust laws. That backdrop of federal antitrust laws is the imposition of atextual limitations upon the city of North Myrtle Beach's power under 57145.
But Mr. Moss, under your view of things, it would be perfectly fine for the municipality here to grant a monopoly essentially to a market participant. That's the very antithesis of antitrust law, right? So why is it any different for a municipality to do the same thing?
Well, this municipality is engaged in anti-competitive conduct. In fact, they had a 25% price increase in their...
Right, but under your reading of the statute, they would be engaged in every bit as anti-competitive statute by granting an exclusive franchise to one single purveyor of these services, right?
They absolutely could do that. They could grant a franchise to one purveyor so long as that purveyor was competitively procured for a duration of no more than 7 years. When you
That
allow...
would seem odd then, that what, I mean, if in fact the statute were to read as you suggested, it would seem to require an affirmative statement. The state and or municipality may only proceed if it grants an exclusive franchise to one market participant, but it doesn't say that.
And it doesn't say that they can. So hence the lack of a clearly articulated state policy to displace competition in this marketplace. 57145 under South Carolina Code has nothing to do whatsoever with beach equipment or delivery and setup of beach equipment. It has nothing to do. It has to do with providing of lifeguards and public safety services. And so it is a very expanded reading of 57145 to even include any notion that allows them to set up beach chairs or beach umbrellas on the beach or to rent them. I submit to you that the deference given to municipalities and counties is being exploited by North Myrtle Beach in this area, and it's done for profit. And it's exactly contradictory to the notions of the Parker Brown immunity, state action immunity, because this is not regulatory activity. This is proprietary activity for profit. And when you allow this to happen unchecked, you get municipalities engaging in proprietary functions for profit, perhaps to offset fiscal woes, perhaps for other purposes. But 57145...
but the services, the funding is going 100% to lifeguard services. Does that make a difference?
Well, firstly, I don't think that's correct information, but secondly, it doesn't make a difference. My reading of the analysis in all of the cases in the Supreme Court and the Courts of Appeals, the financial motivation for it is irrelevant to the analysis. I suspect every proprietor of every monopoly would believe and assert that they have a need for the funds. I would suggest to you that this circuit could adopt its own version of the market participant analysis where you would require a showing. I mean, we know that the municipality here has the burden of proving that they're acting according to state action, okay? Our case law tells us that. They have that burden. But I would suggest to you, without something more specific by the state legislature, that market participants should not be granted that immunity. And we do get specifics by the legislature. It happened right here in Richmond in the Western Star opinion. That state statute specifically gave entitlement and empowerment to engage in anti-competitive activity exactly as they did. I mean, the court got it right in that opinion as far as I'm concerned. And in Phoebe Putnam, they got it right, because in that situation, the town of Eau Claire was entitled and empowered to install sewer service to limit the geographical area they would serve and to refuse to serve non-residents or areas outside of their jurisdictional limits of their town. I think that was a correct opinion by the court. I know it was a correct opinion by the court. That's their guidance. Their guidance is the enabling legislation allowed them to engage in that anti-competitive conduct in the field of providing public sewer. That did
Mr.
not
Moss,
happen.
I'm sorry to interrupt again, and I know you can't predict when I'm going to speak, but I apologize for that. But before you sit down, I think you've got half of the sort of analysis here correct, but I think you need to help us with the other half. So you say that the statutes have to clearly express policy allowing this, whatever activity is being regulated to occur. I think that's half right, because then the cases also say that the resulting policy enactments have to be reasonably foreseeable result, which is not clearly as onerous, I think, as clearly expressed, and the cases seem to suggest that it's a pretty low bar. So why isn't what the city has done here clearly a foreseeable result of the policy enacted by state regulators?
In 57145, the city is empowered to provide lifeguards using its own staff and to provide public safety services. Nothing about that has anything to do with beach equipment. Nothing about that has to do with umbrellas and chairs.
Maybe not directly, but isn't that, isn't one way to do that, the way that this statute and regulation does it, by funding the cost of the lifeguards and providing, instead of providing an exclusive franchise, taking on that service itself to fund the regulatory aspects of the statute, which is clearly within the purview of the city, that is to protect its citizens by hiring lifeguards.
Certainly that's what they're doing, but with all due respect, I haven't read one case opinion in any circuit or the Supreme Court that suggested that the utilization of the funds for any particular purpose was part of the analysis.
All right. I'll ask my colleagues if they have any additional questions before you sit down.
Not right now.
Okay. Thank you very much, sir. You've
Thank
got
you.
some time left for rebuttal. Mr. Dorn?
Good morning. Thank you, Your Honor. My name is Elbert Dorn. I'm here representing the city of North Myrtle Beach. My co-counsel, Kirsten Small, is with me. This case is important not only to the city of North Myrtle Beach, but also to all South Carolina coastal communities, cities, towns, counties who govern, regulate, and protect South Carolina's beautiful beaches, which are, a source of recreation for its citizens and tourists, but also it's the crown jewel of tourism for the state. So while this case is important in that broad sense, as has been noted in the briefs and by questions this morning, this case really presents a narrow issue concerning the appellant's optional on-beach delivery and setup of beach gear on the beach in North Myrtle Beach and the city's regulation of the beach activities, not a prohibition, not a citywide ban that has been in place for years and one with which other beach gear businesses have complied. Importantly, this is not a case of some quasi-state entity that is infected and controlled by private interest or private actors. As has been noted this morning, the city is a political subdivision of the state. It performs critical lifeguard and beach safety services on its 9 miles of beach. And it does so with its own employees. And it separately operates the beach gear function. This is important. There are no private actors, third parties, contractors, or participants involved at all. It's all done by the city.
That's because there's no competition. That's always a result when you have a non-competitive type format like that. So that wouldn't be any surprise. You've covered it. The question is, have you correctly and appropriately done so? I know the result will be there's nobody else to be involved because you made sure that, because you've taken care of that. You've taken it on yourself. The issue here is whether or not you've appropriately done so. And we talk about anti-competitive activity. That's something we're very careful about because the whole American spirit of enterprise, and we do it in the private sector. That's kind of the basis of our sort of economic democracy, if you would, right?
Correct, John.
So we have to be very careful in terms of we're going to just carte blanche take proprietors and other competitive people in the private industry from this activity. So you're saying, could you do this without this statute? Just say, we're gonna take care of the beach chairs and umbrellas. Could you do it without this? Or do you need this authority? We're trying to understand what your powers are. Don't you need this statute to do it?
Yes,
What-
sir.
You need that, right? So then we have to read this in such that it permits it.
That's correct.
And you would concede that it does not specifically talk about the county or undertaking this itself, does it? That seems like more ink is used in terms of how you would competitively sort of bid this thing, and one person would be allowed the monopoly, or one entity, if they're successful. Am I right or wrong about that? You tell me, because you're an expert.
If the statute were exercised by the city to farm out, so to speak, the services, beach lifeguard services, the statute's about lifeguard, to a third party, then that third party, would be able to use those powers to also, rent beach gear and things on the beach. But the key is, the statutes are tied together. 5730 is, in general, a home rule statute, but it was amended in 1999, and Judge Dawson, in a very well-reasoned order, analyzed all of that and tied together the passage of the section in 5730 that says it gave municipalities the right to grant franchises and make charges for the use of public beaches, along with the passage of 57145. And that's a very key fact and legal point for our case. Those two statutes were amended in the same act, and that act, as Your Honor has recognized, 57145, allows the city to provide lifeguard and other safety-related services on and along the public beaches, and to enact and enforce regulations it determines necessary for the safety of all persons on the beach. And, while our argument is on this is an authorized, a clearly contemplated activity, because as Judge Diaz mentioned, the statute specifically talks about renting beach gear. It links together the lifeguard duties with the beach gear rentals, because it pays for it. And this is not, as Mr. Moss said, I respect him. We've been in this case 3 years. We have other cases. This is not a profit enterprise, as he said. The city pays a lot of money for 100 lifeguards up and down the 9 miles of beach, for beach patrol, for beach sanitation, and this beach gear rental helps. It goes 100% to pay for the lifeguards, and then it supplements.
Mr. Dorn, sorry to interrupt
Yes,
you.
Your
Can I
Honor.
ask you two questions related to that? Is that dispositive here? If, for example, the monies that the city got from the rental of beach chairs and umbrellas went somewhere else, to education or some other part, police force services, would that change the result?
Well, I'm not sure in the abstract, but I do think that it's important to show that the activity of the city is in the contemplation of the statutory scheme. In other words, the statutory scheme that was passed in 1999 contemplated that beach gear rentals and would be used to fund lifeguards, which is very expensive. And so.
Yeah. But isn't it, I mean, I thought you had made a separate argument in your briefs, and maybe I'm just imagining it, that there's also a safety component to this beach gear rental because of umbrellas flying all over the place and posing a
Correct.
danger to others on the beach. Is that right?
That's correct, Your Honor. The
So
city,
it seems to me that you could do this, again, I don't want to put words in your mouth, that this is a separate regulatory issue that you could handle, irrespective of whether or not those funds went to lifeguard services.
That's correct, Your Honor, and we fully briefed that point, and that is a secondary position, is that standing alone, the city has authority under 5-7-145A to, quote, enact and enforce regulations it determines necessary for the safety of all persons on the beach, end quote. And this use of the heavy-duty gear, the monitoring of the gear. We have attendants that are out there on the beach, whereas the appellants, they drop stuff off in the morning, and they don't come back until they pick it up in the afternoon, unless there's a storm that blows up or something. And but for the most part, they leave the scene. We stay on the scene. Our 100+ the lifeguards are there, but also the beach rental employees are there.
So let me ask you about, sorry, again, and you just raised an interesting point. So Mr. Moss's clients are not completely barred from providing services on the beach. They just can't do the on-beach installation of chairs and umbrellas, which, it's not an insignificant handicap, because obviously people are more likely, it would seem to me, I know I would, prefer to have somebody put the umbrella down and have to do it myself. But I suppose in theory, you could just completely bar them from engaging in this service at all, because the city could say this is just too much of a safety hazard for the reasons you just expressed. And again, I'm not putting words in your mouth, but tell me if you agree with that. Could you just completely say, we're not going to let them do any of this work?
Absolutely. Not only could we bar that activity, but we could absolutely bar all commercial activity. And other beaches in South Carolina do that. Sullivan's Island, for example, bars all commercial activity. That authority is within the province of the municipality under the South Carolina statutes and Constitution.
So you can only buy a state hot dog?
Well,
I mean, that's what you said, man, all commercial, so right, all the condiments and everything's got to be ketchup certified by the state. But are you saying that you could just take over the whole thing, right?
well, for those familiar with South Carolina beaches, there is no commercial presence on the beach. And that's an important factor of tourism and of the industry, and that we want to keep our beaches, free of that. We don't want it looking like
And that's what it really is, right? You really want to control the atmosphere of the beach, and at writ large, really, don't you? Don't you?
That is one part of it, Your Honor.
That's
but,
a big part of it, isn't it?
Well, the other part of it is that we need to pay for lifeguards, and lifeguards are expensive, and it's an important safety function. And there were 3 drownings on the Grand Strand that I know of this summer that, the rip currents and things
I don't think
like
any convincing about it that lifeguards are important and essential to beaches. I don't think so at all. I don't think that's the issue. The question in terms of Chief Judge Diaz talking about the question you talked about, the funding, perhaps it gave you maybe some good, I wouldn't say it's advice, but a query for you to think about. You said secondary, but perhaps it's the primary one is the safety aspect, because you're linking, it says for safety type things, a lifeguard, and you're linking it because, well, the beach umbrellas are important because they fund this activity. You could do that with a lot of things. Off the beach, you could say, well, it's for lifeguards, but we're going to take a monopoly on this aspect too, and link it because we use the funds from that activity to have lifeguards. It's a lot of elasticity if you start talking about using funding to connect that. Well, this is not a safety issue, but it is going to fund something that is a safety issue on the beach, and therefore we can be anti-competitive.
Your Honor, I would respond to that by saying that it's possible for us to do anything, but we're doing something that is specifically contemplated by the statutory scheme. That is, renting beach gear that is linked together with the provision of lifeguard services. We wouldn't do something that wasn't authorized by the statutes. And, it's
Well, we don't know. That's for us to decide whether or not it is. That's the legal question, isn't it?
Your Honor,
That's why we're here for.
we're not selling.
Excuse me. That's why we're here today, for legal determination, isn't it? You said we can do anything.
That's
right?
correct.
Right?
That's
Okay.
correct.
Go ahead.
That's correct, Your Honor. We're not selling hot dogs. We're not selling hamburgers. We're not selling jewelry. We're not selling shark necklaces.
No, you're taking care of the umbrella industry and chairs. That's what you're doing. The deck chairs.
We're renting chairs as contemplated by the statutory scheme. And this is, something that, as noted earlier, the authorities in Western Star and in Phoebe Putney and in Boulder, City of Boulder, say that the state policy to displace competition with regulation, obviously needs to be clearly articulated and affirmatively expressed, but specific authorization to engage in the anti-competitive conduct is not required. So technically, it's not required that it be spelled out that we can rent beach gear, but it is. So we're even, a step ahead of that because 57145 does spell it out. It's sufficient that anti-competitive activity is the foreseeable result of the state policy. So the statute itself doesn't have to say that the city can rent the beach gear if the scheme, the statutory scheme, that is the part that was passed in the same act in 1999 in 5730 to grant franchises and make charges on the public beach, is with 57145 contemplates anti-competitive activity, then we are entitled to state action immunity. That is our position, Your Honor. And the authority to grant a franchise is inherently the power to displace competition. So, the statutes give us the right to franchise out lifeguarding.
So, Mr. Dorn, again, sorry to interrupt, but that does make sense. But I suppose the reasonable corollary to that is that if you don't grant a franchise, then the market then takes over and participants are then able to engage in this commercial activity. There's nothing in the statute that expressly says that the alternative is for the state to do that. That's what Mr. Moss's position is.
Let's talk about what Mr. Moss wants. Under the statute, one thing that's always puzzled me in this case is if there is a ban on, say that the city decides we don't want lifeguards, that's perfectly within their purview. We're not going to pay for lifeguards. There's plenty of beaches up and down the coast. Pawleys Island, where I live, doesn't have lifeguards. And like I said, there were drownings this year. But just say that we have a complete ban on any commercial activity, like Sullivan's Island. Then the appellants would not be able to operate on the beach, okay? If a franchise were allowed for the lifeguard business, like it used to be in the old days, then they don't have, when I say they, the appellants don't have any lifeguard capability. They just want to rent the beach gear and get the money, but they don't want to provide any safety services along with it, like providing for lifeguards. So if it were to be franchised, these appellants would not get that franchise because they don't do lifeguard operations. And if the city franchises a lifeguard function to a third party, it's the same effect on the appellants.
Well, I think Mr. Moss would say they don't do it now, but they might if they could be allowed to do it.
That's not so easy. Running rental gear out of your garage is not so easy as staffing 9 miles of beach with 100 lifeguards and training them properly. And the city of North Myrtle Beach is the only USLA, United States Lifeguard Association, certified lifeguard crew on the Grand Strand, in fact, on the South Carolina beaches, because it avoids the dual role. These franchises, what they would do is they would have sometimes the lifeguards renting the beach gear, and they would be doing what's called a dual role, trying to watch the ocean and trying to rent beach gear. The city does not do that. We have separate employees serve as lifeguards, separate ones renting the beach gear, so that there's not some dual role where it takes or distracts from the lifeguards. There was a huge case.
You could have a third set of employees selling state hot dogs, I suppose, too, right?
I don't see that in 57145.
Well, I'm just.
Yes, yeah. It could be.
You don't need to answer that.
It could
Sorry.
be, but I'm not here to advocate for that. I'm not here to advocate for unlimited, authority of the city. And if my comments have been construed to infer that, that is not the intention. The intention is to show the court, as Judge Dawson, that was a carefully crafted order on his part. I do give him credit for an exhaustive, detailed order, and he tied together the authorities between the two between the two statutes. It's part of the same statutory scheme. And, you know, frankly, I really can't enunciate it any better than that. I mean, it is a well-reasoned order. And it is, you know, as far as this market participant concept, it has not been adopted by the Fourth Circuit, as Judge Benjamin said. This court, 4 years ago, rejected it, called it a novel theory, and did not apply it. And, you know, this case falls within the parameters of Western Star. I mean, think of the non-emergency medical transport is really, along with the emergency transport that was involved in Richmond, I mean, the non-medical transport is basically shuttling patients to doctor's offices. It's like a glorified Uber. That is a very lucrative part of that contract. And that's what the Fourth Circuit allowed in Western Star, was it upheld the statutes that said that you can also provide the lucrative non-medical transport, shuttling people to, or patients to doctor's appointments, but you must also perform the life-saving emergency medical services. Just like here, where the city performs and pays for some $4 million, or $3 to $4 million in lifeguard functions and beach patrol functions and beach cleanup. And it also, to underwrite or to help defray the cost of that, sells the beach gear on the beach. You know, nobody has to buy it. Nobody has to sell it. I mean, nobody has to rent it. You can bring your own gear to the beach. Mr. Moss's client, Cherry Grove Beach Services, can do like the other three competitors. They've been doing it for years. They bring it to the condominiums. They bring it to the end of the beach street. They bring it to wherever they can meet the rentor. But they don't set it up and deliver it on the beach and leave it. Thank you.
Thank you, Mr. Dorn. Mr. Moss, you've got some rebuttal time.
In further response to the question that I got from you, Judge Benjamin, about subsection 3 of 57145, I would ask you to note that the language of the statute under subsection B clearly says if the municipality elects to provide these services by agreement with a private beach safety company, then the following conditions apply. And subsection 3 is one of those conditions that applies with the private safety company. That's expressly in the statute. I want to suggest to you that we do not quarrel with the city's authority to impose public safety rules and regulations. That's the regulation protected by the Parker Immunity Doctrine. But that's not what's happening here. There's not a single regulation about the type of anchor you can use to anchor an umbrella in the sand. There's not a single regulation about the size of an umbrella. There's not a single regulation about the size or type of a chair that's being used or the weight of a chair. These are all things that could be implemented, but they're not. I suggest to you that the suggestion that this is about public safety is trying to sway the court's deference to the municipality for public safety. It's not in play here. There was a misstatement earlier about all of these funds being used to fund lifeguards. That is a factual misstatement in this record. In fact, our discovery documents revealed that money was taken from this fund and put into the recreation fund for the Parks and Rec. Surplus money was pulled out and paid over to another recreation project that the city had. And so this is profit motivated. And we talked about hot dogs. You talked about hot dogs. Well, that doesn't happen. But what does happen is the city engages in selling lemonade on the beach.
But you keep you're trailing off. It keeps your volume up.
I'll try to do that.
Thank you.
My daughter worked for a company called Sunset Slush, and she pushed a cart up and down the beach when she was a teenager, and she sold lemonade and slushies, but not in North Myrtle Beach. In North Myrtle Beach, it's prohibited. Only lemonade sold by the city.
You can't sell slushes on the North Myrtle
Not in
Beach?
North Myrtle Beach. It's another one of these anti-competitive activities that is certainly not part of the statute. But that's what they do. This is a revenue-protecting, profit-motivated scheme by North Myrtle Beach. And as best we can tell from our inquiry, it's the only beach in South Carolina that does this. The others follow the statutory scheme and grant franchises, or they don't have it at all. But North Myrtle Beach is the only one we found that engages in this proprietary conduct. And it's simply not the conduct that was protected by the Parker Immunity Doctrine. Now, let me suggest to you that.
So if it, I guess is your position that that they have the right to, I guess, contract with a private beach safety company, but they just can't do it themselves. I mean, if they have a right to do that, why can't they? I mean, they own the right to do it themselves, right?
I think they can do it themselves. What they can't do is pass an amendment to their ordinances in 2022 to prohibit anybody else from doing it, unless they granted it to a franchise. The city could certainly have that service, but making it exclusive to the city and not granting a franchise is a step too far under this statutory scheme, in our opinion. They certainly could compete with private enterprises if they chose to do that. They would have a decided advantage.
But if they can exclusively grant it to a private company, why can't they exclusively grant it to themselves?
Well, that's not
Right.
clearly articulated in this statute, and in our opinion, not reasonably foreseeable under the language of this statute. It's obviously for the court to decide.
But
But-
can't they, I think it's their position is that they can look at 5730 and 5730 and 57145 together, and it, because of those two together, it gives them that right. The home
Well,
rule
that's what their position is, and that's indeed what Judge Dawson did in the order, but that's not what any other opinion that I've read shows the analysis is supposed to be under the Parker Doctrine. And I need to touch for a moment on something that I haven't had a chance to. In the order, 514 was the ordinance that existed for years. It was passed pre-e-commerce. My client's business model was solely to take reservations and payment on the internet. Nothing in 514 envisioned that would happen. And so it was never conclusively determined that my client's business violated 514. It was admitted by Attorney Dorn in direct response to the court's question whether or not 514 prohibited the offending activity, and the admission was no, it doesn't expressly admit it, but it's always been our position. Well, even with that admission, that it doesn't expressly prohibit it, Judge Dawson's order found that it was prohibited by 514. I suggest to you that Judge Dawson may have started with the result he wanted and drafted the order accordingly, but we believe the analysis is flawed, and respectfully, we hope you will see that.
All right, thank you very much,
Thank you.
Mr. Moss. I want to thank both counsel for their fine arguments this morning. My colleagues will come down and greet you. I can't do that, but thank you very much for being here this morning. Seated. Our second case is 25-1028, McGinn versus Broadmead. Mr. Hummel, whenever you are ready.
Thank you, Chief Judge, Your Honors, and may it please the Court. My name is David John Hummel, and along with my colleague Andrew Rosinski, we represent the plaintiff appellant Eleanor McGinn in this matter. I would like to make two basic points for this argument. First, consistent with the controlling precedent of J.D. versus Colonial Williamsburg, there are fact issues as to whether Broadmead sufficiently can account for Ms. McGinn's celiac disease. And second, the district court failed to construe the record in favor of Ms. McGinn, which would render her claims not only timely but worthy of a jury's attention. Starting with the equitable relief, the first issue, It is an agreement between the parties that Ms. McGinn has celiac disease. She has no margin for error, so if she consumes gluten, she can suffer short-term and long-term consequences that could be dire. With that in mind, she has requested two particular forms of relief, inequitable relief. First, a reasonable range of safe gluten-free food, which would inherently require a safe and reliable menu. And second, a certified gluten-free kitchen with adequately trained staff. In terms of implementing these requests, they are easy to implement, they are not difficult to master. Hospitals do it, restaurants do it, universities do it. As cited in amicus briefs, there are two universities, Lesley University and Rider University, in which the Department of Justice entered into public settlements to require gluten-free accommodations. It is not cost prohibitive. For instance, in Ms. McGinn's papers, as well as in the amicus brief of the National Celiac Association and Disability Law Center of Virginia, there are citations to a company, for instance, Menu Trinfo, that would certify a kitchen to be gluten-free. And even the company that Broadmead used to do its single online training course, the gluten-free certification program, also offered certification. And last I checked this morning, it cost about $1,300. And without receiving those accommodations, Ms. McGinn, as a paying customer, she's not getting what she's paying for. And in terms of federal law, she's not receiving a like experience as compared to her peers at Broadmead. When
Mr. Hummel, can I, sorry to interrupt you. So there were a number of changes that the facility implemented that the record shows. Is your argument that those didn't go far enough? And if so, where do the deficiencies still lie?
Chief Judge Diaz, the inefficiencies still lie in implementing Ms. McGinn's two requests globally. The district court erroneously stated on JA 813 that Broadmead implemented a safe, reasonable range of gluten-free options and entered into a certified gluten-free program. There was a change in which Broadmead entered into single online training courses, which depending on the user took anywhere between 60 minutes to a few hours to take that course. But Broadmead admitted in its papers before the district court that they did not implement the full range of safe gluten-free options, and there's nothing in the record to say that they entered into a certified gluten-free program. And another change, Chief Judge Diaz, is the labeling system from gluten-free to gluten-friendly. And gluten-friendly expressly disclaims whether the food is or is not gluten-free.
Was that part of the original record in this case? Because I think there's a timing problem there for you, right? Because that occurred after the fact.
It did occur after the fact of when the lawsuit was filed, but there's a reasonable inference to be drawn that in 2024, when Broadmead implemented a gluten-friendly labeling system, the reasonable inference is that with years of experience of dealing with Ms. McGinn, of entering the online course, they discovered they are incapable of ensuring the food is safe and gluten-free. What is in the record at the time of the filing of the lawsuit and admitted in the answer is that Broadmead guaranteed safe gluten-free food for Ms. McGinn in all of its dining venues. When Ms. McGinn first started at Broadmead, she interviewed the then director of dining, Bernard Queen, a number of times. She met with the marketing department. She received a colorful brochure that stated, "We accommodate those with celiac disease and who require gluten-free diets." The then CEO, Robin Summers, said that a person should reasonably rely on these materials. But throughout the lifespan of the case, take, for example, in the summer of 2020, Ms. McGinn consumed a stuffed tomato that was wrongly labeled gluten-free. Fast
I'm
forward.
sorry, before you get to that, I want to go back to the points that you made in response to my first question about what the facility did and what you think needed to happen. And you said that the district court erroneously concluded that what the facility did was a sufficient accommodation. And so the question is that a question of fact, a question of law, a mixed question? And how are we supposed to look at that? Because you say the district court got it wrong, but so how should we consider that?
Yes, Chief Judge. I would say the first here that this case is rife with fact issues. Going back to JD, whether or not that underlying restaurant, the Shields Tavern, sufficiently accounted for whether he had celiac disease or non-celiac gluten sensitivity, that was a fact issue there, even based on those protocols. And in that case, as Judge Wilkinson recounted in the dissent, the head chef completed thousands of gluten-free meals, never received a single complaint. Whereas by contrast here, Ms. McGinn was undisputedly exposed to gluten by Broadmead, and there's issues with
But the issue in JD was not the issue that Judge Wilkinson raised in his dissent, but the question of whether or not the reasonable accommodation of letting the student bring his own food into the facility was sufficient. And we found that that was a question of fact. This is not that case, right? Because the facility is saying, look, we've done A, B, C, D, and E, and your client is saying that's not enough. You need to do all these other things. And then the district court also found that even with those changes, that there was no indication that Ms. McGinn was ever going to go back to eating at the facility. She was cooking her own meals, and she was, to the extent she was purchasing meals, she was giving them out to her friends at the facility. So what are we supposed to do with all of that?
Yes, Your Honor. Let me take that in two parts. First, in terms of what Broadmead implemented, and second, in terms of Ms. McGinn's intent to return. First, in terms of what Broadmead implemented, I think the relation to JD, certainly there's differences in the case of the accommodation that was sought and what happened, but one common thread is, even if an accommodation is being offered, as the majority decision in JD said, that there still may need to be a further accommodation. In here, even if Broadmead entered into the online training, during the midst of summary judgment briefing, Ms. McGinn spotted repeated errors in the menus over and over again. In the summer of 2024, on Memorial Day weekend, and repeatedly in June, there were mislabeled items, and that's what's been happening to her through her entire stay. Even back in the summer of 2020, that's when she received the stuffed tomato erroneously marked gluten-free. So it's clear that Broadmead, whatever they've implemented to date, and they haven't implemented Ms. McGinn's requested changes, it's not enough and they need to do more. Now, turning to the second point, the plausible intent to return, Ms. McGinn does have an intent to return. She lives at Broadmead. She uses the meal plan. There's nothing in the record in which she stated, I will never go back to Broadmead. It's borne out by her actions of making requests. Even in the record at JA 401 to 402 in her sworn affidavit, she discusses one of these recent mislabelings in 2024, where she said that the then director of dining, Dan Hall, was deposed, touted new gluten-free macaroni. In the Memorial Day weekend menu, there was gluten-safe macaroni salad. Now, hearing what Dan Hall said, she was close to trying what that macaroni salad could be, but then, because she's hypervigilant, she asked a staff member to double-check. Thankfully, she did, because the staff member came back and said, it is not gluten-free macaroni. Now, with the request for accommodations, it's important to recognize that, and this is quoting Ms. McGinn in one of her prior affidavits, this is an old age home. The folks there aren't getting any younger, they aren't getting any sharper, and although Ms. McGinn is sprightly, and I would say that if she were not here, she will get older, and there will be a cognitive decline. So she needs to be able to trust Broadmead going forward. She's going to celebrate her 85th birthday in January to make sure that they can take care of her, that she doesn't need to investigate all of their mistakes, as she has done since 2017. She has sent a litany of emails. She has offered to don gloves. She has sent suggestions for gluten-free products, and her requests have gone unheeded. Now, turning briefly to the second point I would like to make in terms of the timeliness and the fact-worthiness of these questions, there's a claim in this case for Ms. McGinn to receive a better variety and quality of gluten-free options. We seek that both in terms of equitable relief, but also in terms of monetary damages. The district judge...
Let me ask you about that, because the incidents from, I think it's the stuffed tomato and the crab cake is, I mean, it appears, well, the argument is that you all have a statute of limitations issue on those, and also maybe the chicken marsala incidents, because they occurred, you know, they occurred, I think in 20, more, let's say, over beyond the statute of limitations period. I just want to hear your position on that. Those are the three incidents that she, I guess, can allege that she was harmed. And she hasn't eaten any of the food since 2021. Do you have a statute of limitations issue here?
No, we do not. I'll table for a second the variety and quality claim, because she does pursue that for monetary harm. But focusing on the three dishes, the stuffed tomato she does not press on appeal. That occurred in June 2020. For the chicken marsala, that is timely. That occurred in January 2021. So focusing on the timeliness of the crab cake, where the district court erred is Maryland's discovery rule. So there's no dispute in the record that Ms. McGinn knew she was exposed to gluten when she consumed the crab cake. She had her hallmark symptoms of violent vomiting. But the difference is, and what the district court overlooked, is knowledge of the harm is distinct from knowledge of the wrongdoing. So she knew that she was injured from gluten exposure. She didn't know what Broadmead did until 2021.
Well, she knew something was wrong. She got sick, right?
She did, and I think that's another fact issue of whether or not she performed reasonable diligence, whether it was reasonably possible for her to obtain that information. Because an important point, Judge Benjamin, is not until 2021 did Broadmead even know that Rice Krispies, which they used as a filler, contained gluten. Ms. McGinn told them during that phone conversation. So there's a question of fact, even if Ms. McGinn investigated further, whether she would uncover what the wrong was. And an easy way to look at the wrongdoing is the breach of contract claim. So it's undisputed between the parties in the contract and upon agreement that Ms. McGinn is entitled to properly cooked meals, and that means gluten-free meals for her. So what she expected at the time was, this is a few months after she came to Broadmead. They're going to take care of me. They gave me the assurances. They gave me the advertising material. A server must have grabbed the wrong crab cake and served me the wrong one. Under that assumption, they made a properly cooked meal. She didn't get it. But what she discovered in 2021, and there's fact issues about this, is if they used Rice Krispies, there was never a properly cooked meal for her. That is poisonous to her, and that would cause gluten exposure.
But even under that first scenario, didn't you have a claim then? I mean, they gave her the wrong meal, even if they had properly prepared a different meal.
It's possible that she could have had a claim based on the server's conduct if she pursued a negligence claim based on what the server did. But in terms of her due diligence of investigating, she sent an email asking if they used imitation crab meat, which can contain gluten, because a night earlier she was at the salad bar and they did have imitation crab meat, which did contain gluten. But even looking at the breach of contract claim, we see that there was no properly cooked meal. So even if she had a claim potentially under negligence, she would not have a claim under breach of contract until 2021. And even for the negligence claim, there are fact issues of the information she had in terms of Broadmead's wrongdoing. She didn't have that information until 2021.
Well, she knew after she ate the food, she knew immediately that she was sick, right? I mean, I understand you're trying to frame it to say, well, she didn't know exactly what they put in the food, but she knew that there was some gluten in the food that made her sick, right?
Chief Judge Diaz, I see my time's up. May I respond to Judge Benjamin's question?
Absolutely.
Judge Benjamin, she did know, and we don't dispute that she was aware of her injury, but it's a dispute of whether she knew of Broadmead's wrongdoing. And Maryland state case law needs to connect whether she had sufficient information to connect her injury to the wrongdoing. And it wasn't until 2021 where she knew that Broadmead, for whatever reason, used a filler that contained gluten. Thank you very much.
Mr. Hummel, before you sit down, let me
Yes.
ask my colleagues if they have any additional questions.
Yes, sir.
Just follow up the last thing you said. So you're saying that it's understood two things. One, she would know if she ate a gluten-laden food because of the reaction is dire and immediate. Two, the sole provider of everything she consumed was the defendant, right?
Yes, that's true.
So why wouldn't she know then, once that she experienced that gluten reaction and she knows who gave her the food, why wouldn't that complete her claim on the contract or negligence? Both, either one of them at that time in terms of knowledge. It's not a duty to investigate. It's at a point you reasonably would have known there is an injury, duty, causation, right? Well, right? Don't you have all of the elements of not saying you're going to prevail, but don't you have every element of a tortious or contractual claim at that time, knowledge?
No, because Judge Greger, we're not aware of what the precise breach was.
The breach was they fed her food that had gluten in it, and it caused a reaction. That's what else is there left in terms of notice for one to be on notice that the statute runs at that time?
Well, because there's a difference between whether or not Ms. McGinn's belief at the time, which is fact-intensive, was whether she was served the wrong crab cake, and Broadmead did in fact make her a safe gluten-free crab cake.
It doesn't matter whether they did it deliberately. It's negligence. Okay, we had a crab cake for her that was gluten-free, but somehow we managed to give her one that wasn't. It doesn't matter what you're saying that until you know that they really deliberately did this, that's not what you require really for breach, is it, or non-negligence?
Well, Judge Gregory, if you're unpersuaded by the negligence claim, then I
Oh, I
would.
didn't say I was unpersuaded. I'm just
Well-
asking you a question. I'm trying to get you to don't put things in my mind.
No.
I'm just asking questions at this point.
And I certainly hope not, Judge Gregory. And certainly on rebuttal, I'll address why your questions are very relevant and helpful to the chicken marsala. But I would say, even tabling the negligence claim, there was no properly cooked meal. And that was Ms. McGinn's belief, is that she thought maybe a server grabbed the right one, gave it to a colleague next to her. It wasn't until 2021 where she knew that pursuant to the contract, there was not a properly cooked meal made. Thank you very much.
Thank you very much. Mr. DeStanislao?
May it please the court, Thomas DeStanislao on behalf of Broadmead, Inc. As my friend on the other side acknowledged, at first blush, this appears to be a complex case with a factually dense record. That said, I'd like to focus on what we see as the cleanest path to affirmance, and that involves two steps. The first is concluding, as the district court did, that the statute of limitations bars Ms. McGinn's federal and most of her state law claims. And the second step is affirming the district court's conclusion that Ms. McGinn failed to produce more than a scintilla of evidence that the chicken marsala actually contained gluten. If the court agrees on both points, the factual disputes, even if construed in Ms. McGinn's favor, become irrelevant. Before I dive into each of those two steps, I do want to set out two overarching themes that I think are borne out in the record and are important to consider here. The first is that if you look through the record, every time there has been an incident in which Ms. McGinn has claimed she has consumed gluten, felt the ill effects of gluten, or found a mislabeling, Broadmead has worked with her and attempted to do so in a fashion where they are joined together trying to ensure that future incidents don't happen. And the second aspect, and this is particularly in reference to her federal claims, Ms. McGinn, as highlighted in my friend on the other side's opening argument, is making frequent complaints about what she calls repeated errors in the menus. In effect, what she's asking this court to do is hold that federal discrimination laws require perfection, absent human mistake. And respectfully, that's not what they are designed to do. And in fact, that is the very reason why negligence claims exist in the first place, because people aren't perfect, no matter how hard they try. And individual incidents of mistakes do not amount to federal discrimination. There's no negligent discrimination claim. Those are independent negligence claims. So with those two themes in mind, turning to the statute of limitations, Ms. McGinn's federal discrimination claims first accrued in January of 2019 when she emailed Mr. Hall complaining about the lack of variety in Broadmead's gluten-free offerings. She's never denied this, not before the district court, not here. Instead, she maintained consistently below that her federal claims were nevertheless timely based solely on the continuing violations doctrine. And I would encourage the court to look at ECF document number 44 in the district court's record, which is her response in opposition to Broadmead's motion for summary judgment, raising the statute of limitations.
Counsel, sorry to interrupt you. I just want to be clear that I understand. When you talk about the federal discrimination claim and the lack of a variety of menu items, are you also including the lack of reasonable accommodation, the ADA claim, in that umbrella of claims?
Under the statute.
Lack of variety and a lack of accommodation seem to me to be two different things.
Under the statute of limitations analysis, which is where I'm focusing our attention now, because the district court held not only that the RA and FHA claims were barred by the statute of limitations, but in footnote 4 made clear that that analysis applied to Ms. McGinn's ADA claim as well. More than happy to go into the standing analysis the court did on the ADA claim. It just struck us that the cleanest path towards affirmance was the statute of limitations.
No, I understand, and I'm following you. I just wanted to be sure that you were talking about the ADA claim as well when you talk about a lack of variety, because it seems like that's different from failure to accommodate.
I understand, Chief Judge, and I think that brings us back to what are the actual accrual dates for Ms. McGinn's federal discrimination claims. When did they begin? She maintained below that it was the continuing violations doctrine, that it was the course and conduct that had occurred. She appears to have abandoned that argument altogether in her reply brief before this court. If you look at page 14, Ms. McGinn refers to the continuing violations doctrine as a straw man that was left behind at the district court and not referenced in her opening brief. I've read it 5 times to make sure that that was, in fact, the waiver that I believe it is. But that was the only argument she raised below regarding the timeliness of her federal claims. And as a result, she's waived any other contention that they fell within the statute of limitations. But nevertheless now, for the first time on appeal, Ms. McGinn asserts that her communications with staff in March and May of 2023 constitute new accrual dates on which she can now rest her federal claims. And she's wrong for 2 reasons. First, she never asserted below that these interactions on their own amount to discriminatory acts under the ADA, RA, or FHA. Thus, she cannot now, for the first time in the case, take the position that they resurrect her statutory limited claims. And second, Ms. McGinn cannot contend on this record that those communications amounted to discrimination. Indeed, Ms. Summers never denied any of Ms. McGinn's requests for which she could have recovered under the federal discrimination statutes. And I'd like to focus on what was actually communicated in those messages in March and May of 23. So in there, Ms. McGinn asked for 3 things. First was full repayment of every penny she's given Broadmead. The denial of that is not discrimination. So I'm going to set that aside for now. The second, she asked that that Broadmead's staff undergo a certification process that she agrees to and is allowed to participate in. In Ms. Summers' response to that email, she said, "We're denying that for now, immediately, but we're going to look into certification." And in fact, in April of 2023, in between the March and May communications, that's when Broadmead paid for and began the certification process for its staff members. So they acknowledged and agreed to that request. And the third is the request that Broadmead expand its gluten-free offerings. And there I would direct the court to JA 560 and 561, which was from the winter of 23 to spring of 24, that explains all of the expansion of gluten-free offerings that Broadmead is going to make. I would direct the court to JA 517 to 27, 599 to 600, 646 to 47, 469, and 691 to 92, all of which are instances where Ms. McGinn has asked for meals to be made gluten-free and made specific requests for how they be made, and all of which that Broadmead has assented and agreed to provide. That again goes back to the theme. Broadmead is working with Ms. McGinn and has been to try and make this as pleasant a process as possible for her. But Ms. McGinn unfortunately suffers from food anxiety, and it's not within the realm of possibility or within the realm of anything a court can order for Broadmead to alleviate her food anxiety.
Are you certain a diagnosis yourself, or something in the record that would suggest that?
Of the diagnosis that she has
Yeah.
celiac disease?
Yeah. No, I thought you said anxiety.
Of food anxiety, that's something that she
Okay.
represented
Okay.
in her deposition
Right.
multiple times. So she's acknowledged that she doesn't eat at restaurants, she doesn't eat with friends, she doesn't eat with family. She prepares all of the food herself.
I assume it's because she can't be certain that it doesn't have gluten in it, right? I mean, food anxiety, never mind, go ahead. But, go ahead, finish your thought.
With Chief Judge Judge Gregory, I think that's an important point.
That's why I said go ahead, I didn't say dismiss your point.
Ms. McGinn suffers from food anxiety, and I think it's important to note, and that's a contrasting point here with JD. So in JD, you have a child who can't eat food containing gluten. He doesn't trust restaurants. And how did the restaurant respond? They said, either you can sit here and not eat, or we're gonna kick you out. And you have to go out and eat your food outside. That is not what's happening here. Ms. McGinn has pointed to no policy barring entry to its facilities. There is no policy in place suggesting that if she brought her own food in, that Broadmead wouldn't let her eat it or would remove her from the premises. At the end of the day, though, Broadmead can't cure that food anxiety, and federal discrimination statutes don't require it to. So, turning to the state law claims, as my friend on the other side already acknowledged, the stuffed tomato incident is outside of the statute of limitations, so that's not at issue. As this court addressed at length, the discovery rule doesn't apply in this context to the crab cake incident for multiple reasons, the chief of which is she's acknowledged that at the time she consumed the crab cake, she believed she had eaten gluten. And importantly, she began an investigation at that point. She affirmatively reached out to Broadmead staff, asked if it had an ingredient that she knew to contain gluten, and Broadmead staff responded, no, it contained actual crab meat.
So what about the chicken marsala incident, since that one was in, I think, February of 2021? Wouldn't that fall, for purposes of the state law claims, within the statute of limitations?
It would, Judge Bennett.
And so why should we disregard that, the February 2021 incident?
Not for statute of limitations purposes.
Yes, yes.
So it falls within the statute of limitations, but it's Broadmead's position, and the record bears out that Ms. McGinn has failed to adduce more than a scintilla of evidence suggesting that the chicken marsala dish itself actually contains
Well, what
gluten.
about, I think it's Ms. Malone, the lady that's over dining services, her emails, they're pretty clear. I think she says that somewhere along the line we fail. And then she said, I was trying to, how somewhere along the line there was a failure. I think that's at JA 595. And then she says again in another email on 597 how we failed again, and how this process has failed. So it seems to be some acknowledgement there from Ms. Malone, who is over dining service, that there was some failure. So how is that not a question of fact on those on that claim?
Excuse me for interrupting you, Judge Benjamin.
Oh, no.
There are 2 points there. The first is I think it's important to look at those statements in the context in which they were made. The statements weren't just, there was a failure. It was, there was a failure and we will find it. Somewhere along the line, a failure was made. There's no actual determination that there had in fact been a failure. What this was a mid-investigation statement to Ms. McGinn, acknowledging, basically trying to say, we're doing all that we can to figure out what happened here. But that's not an admission that there was actually gluten in the chicken marsala dish. And that's important for 2 primary reasons. First is that Broadmead's investigation actually found there wasn't gluten in the chicken marsala dish. When it finished, it concluded.
But there was some, but there's this issue regarding cross-contamination. If there was a possibility that through cross-contamination, I think the gluten flour versus the gluten-free flour was stored close to each other or something, and they moved them apart. I guess what I'm saying, how is that not an issue of fact?
Well, first off, moving them after
Well, I understand
what
that,
happened is
yes.
a subsequent remedial
I
measure.
understand that, but I guess what I'm saying, how is it not an issue of fact, especially with these emails where she is saying that there is a failure? She somewhere along the line there is a failure. I'm not sure if that's not an acknowledgement or not, or admission or not, that there was something happened. She got sick, right?
She got sick, and we're not denying that she got sick, but the burden is on the plaintiff here to prove that there was actually gluten in the chicken marsala.
But that would be an
dish.
issue of fact, right?
Right, and it's our position that at this stage, she hasn't come forward with more than a scintilla of evidence that there actually was gluten in there. And here's why. First, we have the preparer of the dish, who on his own said, I used rice flour. I always use rice flour. And that actually stems back all the way to the 2019 email, or letter that Ms. McGinn sent to Dan Hall, to which he responded at JA 288 that he was going to be making the upcoming pot roast and chicken marsala and short ribs dishes to be gluten-free. So there was a process in place to make this dish gluten-free. We've got the fact that there was that nothing in Broadmead's investigation revealed that there was actually gluten used in this dish. And then we've also got the fact that throughout discovery in this case, the closest that we've come to any suggestion that there was gluten in the dish are these mid-investigation, admittedly poor choice of words, but statements that there may have been a failure and we'll find it. And I would direct the court to the Potts case on that, and that's at 183 Maryland 483, and that dealt with a similar, that was a pre-investigation statement that the court found not to be an admission. But in order for something to be admission, there has to be an actual knowledge of the facts to which you're admitting. And here, merely acknowledging the possibility that a failure had occurred, it cannot overcome the weight of the evidence showing that there was no gluten in the dish. And with that, unless the court has any other questions, I believe I'm happy to address the gluten-friendly labeling if you want, or any other questions the court would have.
I'm just curious, so does Broadmead not have the gluten-free menu anymore since you all switched to the gluten-friendly, even though I understand that was after the fact, yes.
If you look at the labeling on the menu, where it used to say GF, it now says GFR, and then it's got an asterisk that goes down to the bottom of the menu that explains what gluten-friendly is. And that's in the record, and I don't have the site for that. But our ultimate point, and I think this was one that Chief Judge Diaz raised earlier, is that this was a post-discovery change, and this court has been clear that to the extent new claims or new arguments are being raised, even after discovery begins, that needs to be brought in an amended complaint, which wasn't done here. And that's the Sigley case, which the court decided earlier this year.
All right, thank you very much, counsel.
Thank you.
Mr. Hommel, you've got some rebuttal?
Thank you, Chief Judge. Your Honors, I would like to address a few points on rebuttal. First, let me start with my friend on the other side's theme of perfection. He also said that people aren't perfect, and that's true, myself included. Judge Gregory, I put words in your mouth, but we're not asking for perfection here. Ms. McGinn is asking for reasonable accommodations that Broadmead hasn't even attempted, to even try a certified gluten-free kitchen, because the consequences are dire. She's been hospitalized after consuming gluten. She had temporary paralysis. She thought she was going to die after she consumed the chicken marsala. She has no margin for error, and it's not just food anxiety born out of nothing. She has tried to work with Broadmead repeatedly for many years, since 2017, to make suggestions, and Broadmead still fails to implement reasonable changes. And Judge Benjamin, your question about the gluten-friendly labeling, this of course is outside the record, but as of this month, October 2025, there still is the gluten-friendly labeling system. It's on the holiday menu and the Arbor Cafe menu. And it does go to the immediate threat of harm. It goes to actual injury in terms of reasonable deterrence. And at minimum, it confirms what is present in the record throughout the case, is that Broadmead has insufficient protocols to account for Ms. McGinn's celiac disease. At the very least, there's a fact question on that. Let me turn also to the chicken marsala, especially Judge Benjamin, your questions. There are statements in the record which we look at as concessions from Joyce Malone, who is in charge of the dining services, that she didn't question Ms. McGinn's gluten exposure. She said, I will talk to Dan Hall, the then director of dining, about how this process failed. She spoke to Dan Hall, who presumably spoke to the preparer of the dish, who's the person that the district court relied on in ruling that there was no claim. But Joyce Malone still came back and said, somewhere along the line, there was a failure. She could have offered an affidavit at summary judgment to say this was customer service talk, or we concluded that there was no failure, but she didn't. So there's fact issues of whether or not Ms. McGinn consumed chicken marsala contaminated by gluten. And that's also—
So if this case goes to trial, what you have then would be that we found out there was none, but we think that somebody still believes there was a failure. You think that would be much more than a scintilla of evidence in terms of proving that fact? Because it's summary judgment, we do it all the time in terms of Title VII cases. A lot of times people say, no, I know I was fired because of this reason. And then we say, no, nobody did this and that and that. The fact you still protest, we have a lot of cases like that in that sense in terms of discrimination cases where it said, no, you haven't shown it. So what would be that? You mean solely because, and I'm not discounting at all, it's very important. Obviously, this is a serious matter, no question about it. But saying that I ate it and I was sick, and that's enough if there's evidence that the chef said it wasn't, and that you think that would be enough to carry the ball in terms of being more than a scintilla of evidence to prove that fact?
Yes, Judge Gregory, with the whole picture of the record. So the district judge looked at Ms. McGinn's testimony. I know my body. I consumed the chicken marsala within 2 to 3 hours. I vomited. There are remnants, not great breakfast fodder discussion, but there is a picture of the vomit in the record. But it's more than just Ms. McGinn saying that she was exposed to gluten, and more than her experts saying, given the consistency of her symptoms, there was a gluten exposure. It's not only Joyce Malone's statement of a failure, but no one at Broadmead questioned that Ms. McGinn was exposed to gluten. There's testimony from Jarrell Fleming that Joyce Malone recited. He was the executive chef, where he thought what possibly happened was the flours were mixed. Those are binding statements. A jury can consider that. When Ms. McGinn spoke with Joyce Malone, Dan Hall, and Jarrell Fleming in February 2021, they all professed ignorance. They didn't disclaim what she said. Dan Hall has stated in the record if there was incorrect information presented to him, he would correct it. He did not do so. The then CEO, Robin Summers, stated, Ms. McGinn, I'm sorry you continue to experience reactions to gluten. I think with all those pieces together, there is enough for a jury to go beyond a scintilla and even requiring the meager evidence that Maryland requires to send this case to a jury. And they could rule that Ms. McGinn consumed a chicken marsala that contained gluten.
So you think this case allows a strict liability almost? That if she became ill from eating it, it's strict liability?
It depends on the circumstances, and I think this goes back to our—
But those are the only circumstances, really, isn't it? That is, she ate it and she became ill, and therefore you must say it had gluten in it because she was ill, and therefore they're responsible because there's no question they served it. So that's strict liability, isn't it?
Well, I say it depends only in the sense of, let's say, the crab cake example. If a server did do what Ms. McGinn thought at the time of erroneously serve it to her, there could be a dispute of whether or not that's negligent behavior. But I would say for what I was discussing in terms of chicken marsala, yes, in the sense of the contract guarantees properly cooked meals. If it wasn't properly cooked, that violates the contract. And in terms of negligence, there's enough evidence in the record that we would submit that there are fact issues of whether or not there was a duty, breach, causation, and damages because of what Broadmead knew, what they did with the rice flour. And I know that there are subsequent remedial measures, but it's not as if Ms. McGinn could even test the rice flour because they sanitized the bins and restocked them. Now, turning to the claims in variety, my colleague on the other side mentioned those about January 2019. There was no waiver. There's no waiver argument in the opposition brief. These claims were presented to the district court at ECF 39 at page 10. Broadmead stated that they did not provide the full request for reasonable range of gluten-free options. Those are claims the court can consider, and certainly January 2019 should not be the starting point because, for example, Ms. McGinn is harmed every day she cannot consume food. There was a spring cycle menu in 2023, which assuredly did not exist in January 2019. There's also the bistro dining venue, which did not exist until 2022. These are new harms that bear out the principle in this court's case in Hill of a renewed request for accommodation triggers a new statute of limitations. And finally, I want to make clear in terms of the equitable relief, Ms. McGinn is under a constant and immediate threat of harm because of Broadmead's insufficient protocols. There are fact issues about that. She suffers an actual injury from her reasonable deterrence to consume that food, even though she has a intent to return and a past injury. And there's the economic injury because she is paying every month for the meal plan. She pays $330 per month. It's not the quarterly meal plan that the district judge cited, and she did not receive that in full. Chief Judge Diaz, I see my time's expired. May I conclude this thought?
Let me ask you about that related to that. She's no longer paying for the meal plan, right? Or is she?
She is.
Okay. I thought there was some evidence in the record of a refund for some amounts of money.
There's
Is that
evidence
right?
sorry, Chief Judge. There is evidence in the record that Ms. McGinn requested to opt out of her entire meal plan, which is $330. But Robin Summers, the then CEO, said she would honor this request in the form of the away meal credit, which does not encompass the full $330. If you look at JA 644, it shows what the away meal credit is, and it's a fraction of what the meals are. Ms. McGinn, this comes from page 5 of the opposition brief, although there's the wrong citation. It correctly states that Ms. McGinn has a monthly plan in which she receives a credit because she receives one meal. So she pays $330 as a starting point, but because she only consumes one meal per month, she receives a $126 credit at the end of the month for what would have been the other two meals. Even Robin Summers' offer of the away meal credit wouldn't subtract the remaining dollars. So even the offer that Broadmead made wouldn't relieve Ms. McGinn of the responsibility of paying money every month for a service she does not use.
Well, there must be some foods that she could eat, and there's clearly no question of gluten in it. I mean, fruits and some vegetables and things like that. I mean, there must be that because you're suggesting that it's not a full refund. That's because, and maybe you tell me, I don't know, aren't there some things that clearly is gluten-free itself that she could eat, I mean, comfortably eat, right?
Assuredly so, Judge Gregory, but that goes to the like experience standard, which is relevant for the equitable relief, as well as the monetary claim for variety and quality, just because she needs a like experience compared to her peers. If they have 20 some odd options, but she has plain fish and plain chicken and fruit, she's 84 years old and this is her retirement. She wants to kind of enjoy the benefits. It's a cliche, but variety is the spice of life, and she wants different meals on a daily basis, as other residents do. Thank you very much, and I'll ask this court to vacate and remand for further proceedings. Thank you.
Thank you, counsel. Appreciate both counsel's excellent arguments this morning. Before my colleagues go down and greet you, I want to ask them if they want to take a break or move on to our third and final case. Judge Benjamin?
I don't need a break.
No, I'm fine, go forward.
All right. Then they'll come down and greet you, and then we'll move on to our third and final case. All right, our third case this morning is 24-7049, Edwards versus Witherspoon. Mr. Longley?
Good morning, Your Honors, and may it please the Court. Joseph Longley for Appellant Tracy Edwards. I'll be covering the issues regarding medications for opioid use disorder, while my colleague Shana Carter will be covering the issues around shackling. Defendants in this case forcibly removed Ms. Edwards from the only effective medication for her opioid use disorder, buprenorphine, one of 3 FDA-approved medications for opioid use disorder. They didn't do this because of her individual medical needs. They did this pursuant to a blanket policy that said no matter how severe your opioid use disorder, no matter what your individual medical needs are, you will not be getting medications for opioid use disorder unless you are pregnant. This caused great harm to Ms. Edwards. Ms. Edwards described the pain that she experienced as worse than the pain that she experienced in the childbirth that she had just gone through. This happened immediately postpartum, and it left her at a severely increased risk of relapse, overdose, and death. This conduct violated both the 8th Amendment and the Americans with Disabilities Act. As this court has held in Gordon and Delonta 1 and 2, a blanket policy based not on someone's individual medical needs, but rather on administrative convenience or some other non-medical factor can amount to deliberate indifference, and here it does. Here Ms. Edwards was subjected to this ban and was not allowed to stay on this life-saving medication.
So you don't think that oxycodone taper was sufficient for purposes of under the 8th Amendment, I guess, the deliberate indifference claim?
No, Your Honor. I think a reasonable jury could conclude that oxycodone was not sufficient. In fact, oxycodone was the very medication that caused her addiction in the first place. It's not FDA approved or medically appropriate to provide oxycodone to somebody with opioid use disorder. It's not treatment for opioid use disorder. It's also not treatment for tapering from medications for opioid use disorder.
Counsel, can I ask you about that? So that sounds like a pretty good negligence claim, but how is that deliberate indifference? Or I suppose you have an ADA claim as well, but with respect to your 8th Amendment claim, how does that amount to deliberate indifference?
Well, it's deliberate indifference because it doesn't have anything to do with her individual medical needs. Now, if this were a case where Ms. Edwards got an individualized evaluation and a doctor determined that medications for opioid use disorder were not medically necessary for her, then that would be a negligence case. But here, she didn't receive an individualized analysis of her individual medical needs. Instead, she was subjected to a blanket policy that no matter how severe your opioid use disorder, you can't get access to this medication. And so that's a categorical ban that doesn't amount to negligence.
Right, but I guess that might be a better case if they provided nothing, but someone prescribed this alternative medication, oxycodone, as a taper, even though you disagree that it actually was. But so again, why isn't that simply negligence?
Well, it's not negligence, Your Honor, because a reasonable jury could conclude that that wasn't treatment at all. Again, there's record evidence from Dr. Allison Stube.
But that is treatment. It's not the treatment that she might have preferred or the treatment you think would have been ideal, but it's a treatment of sorts.
It actually exacerbates her condition.
And again, that sounds like a great negligence claim, but this is not a case where they denied her everything or gave her nothing.
Well, Your Honor, if this was, another medical condition, for example, diabetes, and she was provided insulin just during her pregnancy, and then for 9 days she received a medication that's not approved to treat insulin, that would amount to deliberate indifference under the ADA. Deliberate indifference under, both the ADA and the 8th Amendment. And here, by providing a completely non-responsive medication, not based on what is her individual medical needs, but rather based on a blanket policy that has nothing to do with the actual clinical criteria for opioid use disorder, and it's not a treatment for opioid use disorder. So a reasonable jury could come to that conclusion, and to conclude otherwise, this court would have to find that a reasonable jury could not. For the Americans with Disabilities Act, and I'll add to that, Your Honor, as well, that in Gordon, this court found that, despite the fact that they were providing monitoring, that was not enough to defeat an Eighth Amendment claim. In Delonta, they were providing Prozac. In Delonta 2, they were providing hormone therapy and allowing Ms. Delonta to dress as the gender that aligns with her gender identity. And the court found that just because there was some treatment, that doesn't amount to defeat her deliberate indifference claim. And so in this court as well, this court would not be breaking new ground in the Eighth Amendment context to say that a reasonable jury could find that oxycodone was not sufficient. As far as the...
You were about to talk about the ADA claim, and I'll ask you about that. And maybe I've just forgotten, but this is the first time that I recall an ADA claim being paired up with a deliberate indifference claim under the Eighth Amendment that I've been on the panel on, and again, maybe I've just forgotten. And it appears that everybody has conceded that opioid addiction is in fact a disability, so that doesn't seem to be an issue. But so is that the line of demarcation? It has to be either a concession or a finding of disability before the ADA kicks in. Otherwise, you're just left with an Eighth Amendment claim. Is that right?
Correct. There needs to be a disability, and here that disability is opioid use disorder. A disability is an impairment that substantially limits one or more major life activities, and Ms. Edwards meets that standard abundantly with the evidence that she's provided about the impact that opioid use disorder has had on her life.
And in fact, I don't think your friend on the other side says otherwise.
Correct.
Right?
It's undisputed in this court that opioid use disorder is a disability.
Okay.
And by categorizing people with opioid use disorder for differential treatment than people with other conditions, the NCCIW violated Ms. Edwards' rights under the Americans with Disabilities Act by failing to provide individualized assessments of her medical needs. And so that amounts to disability discrimination, which courts around the country, including a district court in this circuit, have found in virtually identical circumstances. The U.S. Department of Justice has also put out guidance saying that the categorical ban of medications for opioid use disorder amounts to disability discrimination under the Americans with Disabilities Act. And so here there's no question that she was subjected to this blanket policy, and that singles out individuals with opioid use disorder for differential treatment than, for example, the example that I gave Chief Judge Diaz, people with diabetes. So that amounts to an Americans with Disabilities Act claim. Your Honor, additionally, defendants raise a qualified immunity defense under the Eighth Amendment, but this court in Cinto v. Stansbury, as well as in Eco v. Shreve, has held that the relevant right in question is the right to adequate medical care. And as we've been discussing, there's an abundance of evidence for a jury to conclude that there was no adequate medical care for Ms. Edwards. That's based on the Estelle v. Gamble Supreme Court decision in the 1970s, which of course predates the issues at conduct here, in issue here. If the court has no further questions, I'm happy to hand it to my co-counsel.
Thank you very much, counsel. Ms. Kader or Kadar, I hope one of those options is correct.
It's Cotter, in fact, but thank you, Your Honor.
Oh for 2. Oh my gosh, so sorry.
It's not an easy one. Well, good morning, and may it please the court. Shayna Cotter, also on behalf of the appellant Tracy Edwards. I'm addressing her Eighth Amendment shackling claims. At the hands of NCCIW officers, Tracy Edwards was shackled to the hospital bed by one arm and one leg while she was, quote, experiencing very powerful contractions until she was instructed to push to deliver her baby, and then again within an hour of delivering birth, exposing her to severe psychological harm and causing severe pain. Ms. Edwards was not a security risk. The district court erred in finding that the individuals responsible for this dangerous and degrading conduct are entitled to qualified immunity for 2 reasons. First, because Ms. Edwards' right to be free from dangerous and degrading shackling with no penological justification was clearly established by the Supreme Court's decision in Hope v. Peltzer. It was further clearly established by the decisions of the 6th, 8th, and 9th Circuits, who have unanimously held that shackling a person during this extraordinarily vulnerable time violates the 8th Amendment. Second, the district court erred because the defendant's mental states remain in issue, in accordance with this court's decision in Thorpe and its progeny. Given the open and obvious risk of harm attendant to shackling around childbirth, as well as the evidence in the record that defendants were aware of the state policy prohibiting the very practices in which they engaged, a jury could conclude that the defendants knew that they were engaging in conduct that rises to the level of an 8th Amendment violation. This is enough.
Counsel, I'm sorry to interrupt you, but didn't the record indicate that there was sort of a contradiction in policies that might have led an officer to be confused or at least not fully understand where the limits were?
Yes, the record does include reflect policies that contradict one another, and I think the impact of those policies is different with respect to Defendant Witherspoon, the warden, as to the remainder of the defendants. So the record reflects that the state had a policy that prohibited shackling and during labor, when being transported for labor and delivery, after the induction line is being placed, prohibiting waist restraints, returning to a facility. So that's the state policy. It's located at JA 504, clearly prohibiting the conduct in which the defendants engage. Now, there are also 2 NCCIW policies. Those were promulgated by the Warden Witherspoon. It was brought to her attention multiple times that her policies were not in compliance with the state policy. So as to Warden Witherspoon, we think it's very clear, a jury could easily conclude that based on the fact that she ignored these directives from the state to conform her policies, that she was aware of the harm and risk of harm that was attendant to the practices that she essentially permitted under her watch. That's sufficient to show deliberate indifference on her part. As to the officers, there's really a conflict in the record as to what they knew and what they understood. Each of the officers aver, we followed all the policies, I knew of all the policies, and I followed them all the time. But it's not possible. The policies are in conflict. And so it's not possible to have followed all of the policies at all the times. And the officer defendants state that they were aware of the state policy that was prohibiting the very conduct in which they engaged.
I'm not sure how that helps you. If they say they follow the policies all the time, but the policies were hopelessly in conflict.
Because
how does that indicate that that's an officer acting with deliberate indifference or intentionally?
I apologize for
Go ahead.
interrupting.
No, go ahead.
So one, Your Honor, as to the officers, so there are both the policies, the state of mind can be inferred both from their knowledge of a policy that prohibits this dangerous and degrading act of shackling, and then also from the fact that they actually were applying restraints to Ms. Edwards' body during these extremely vulnerable times. So while she was in the hospital bed, hooked up to medical equipment, experiencing very powerful contractions. And the 6th, Eighth and Ninth Circuits have all said this is an open and obvious risk, and this offends, it's incompatible with contemporary standards of decency. The medical risks and the psychological risks that are attendant to this practice are well known. They're also laid out in the declaration of Dr. Stube. But if I could direct the court's attention to the reasoning in the Eighth Circuit's decision in Nelson, really lays out, that's the first circuit to weigh in on shackling around childbirth, weighs in on both why the harm was open and obvious and why the Supreme Court's decision in Hope establishes the right at issue here. See, that's the end of
All
my
right, thank you very much.
Thank you.
Ms. McHenry?
May it please the court, my name is Laura McHenry and I represent the defendants appellees. This court should affirm the order granting summary judgment for defendants for two reasons. First, plaintiff simply has not put forth evidence to satisfy the elements of her disability discrimination claims. And second, the record evidence fails to demonstrate that any defendant acted with a conscious disregard for a known risk of harm. Before I get into those reasons in more detail, I do want to emphasize that summary judgment is appropriate in this case. While there's some variance in the party's recitation of the facts, the material facts are not in dispute. This case can and should be resolved as a matter of law. Plaintiff asserts that the discontinuation of MOUD after she had her baby violates the ADA and the Rehabilitation Act. But this claim fails because she has not shown that she qualified for MOUD after she had her baby, or that she was denied OUD because of her disability. As the court acknowledged with my friend on the other side, defendants do not contest that opioid use disorder is a disability under the ADA and the Rehabilitation Act. However, where our agreement sort of splits there is on the second and third elements. The second element of her ADA
But
claim.
you would agree that the district court did its analysis based on pregnancy being a disability and not the opioid disorder being a disability.
I'm sorry, can you repeat your question?
Would you agree that the district court did its analysis based on pregnancy, not on the opioid disorder?
I do not agree with that, Your Honor. To me, a plain reading of the order, of the district court's order, demonstrates that the district court clearly understood opioid use disorder as the disability underlying her ADA claim. And the reason for that is because, one, pregnancy is not a disability under the ADA.
But it appears that the analysis by the district court is based on the use of being pregnant and not being pregnant is what the district court did, not disability independent of the pregnancy.
How I read that portion of the district court's order, Your Honor, respectfully, is really more tied to that second prong about whether she qualified. Plaintiff argues that she was removed, that the defendants discontinued MOUD after she was pregnant, and that in itself shows disability discrimination based on her opioid use disorder. But that logic doesn't follow, because the reason she was denied MOUD after she had her baby is not because she didn't have the disability of OUD. It was because she was no longer pregnant. The reason that MOUD was offered for pregnant inmates and not non-pregnant inmates.
I'm sorry, counsel.
Yes, Your Honor.
But that's sort of circular and also nonsensical. How is that a rational policy that someone who's under a disability because of addiction and is receiving what everybody seems to concede is the appropriate pregnancy treatment during pregnancy, all of a sudden she's somewhat less addicted and therefore is not entitled to the same treatment after she gives birth? That doesn't make any sense.
I would agree that would not make sense, but that's not the reasoning, so let me try to rephrase the defendant's position there. I think Richardson v. Clark, a decision out of this court in 2022, is instructive. The issue in Richardson v. Clark was about, at least the ADA claim, was about an inmate who had been receiving in-person ASL interpretation. During COVID, defendants could not offer him that service, but we're able to provide him with video calls with an ASL interpreter, as well as several assistive devices to help with communication and for reading. And this court affirmed summary judgment for defendants, holding that the accommodations provided were reasonable and that plaintiff is not entitled to receive the specific accommodation that he requested, even if defendants were previously able to provide it. And in this court's order, in this court's decision affirming summary judgment, they explain that context matters. And this is important in this case particularly. In Richardson, this court held that our context is a prison. We view the reasonableness of accommodations through the lens of operating a prison, and that vantage point requires some deference to those who run prisons. The ADA just does not require prisons to employ any and all means to make services available to persons with disabilities. That's from page 621 of
Well, but I suppose you could read Richardson as indicating that even though those alternative services may not have been the Cadillac option when it came to options, it was at least a reasonable alternative, and even if not the perfect one in the prison context, entirely appropriate. But here, I mean, your colleague on the other side says that the option that was given to Ms. Edwards in this case was actually no treatment at all. I mean, it was just not, it was exactly the same drug that caused her addiction to begin with. Isn't that the difference that matters?
That's simply not accurate. It wasn't that she...
Well, what's the evidence that this treatment that was offered was in fact a viable option? That all the record evidence, at least with respect to experts, say that that's entirely contraindicated. There's no universe in which this is appropriate. So to point me in the record to where that's you say otherwise, or someone says otherwise.
Sure. On pages 744 to 745 of the joint appendix, the defendants lay out the reasons why, the compelling reasons that NCCIW could not offer MOUD to non-pregnant patients back in 2019. Some of those include limitations on licensure and prescribing authority that were beyond their control. So specific to your earlier question, Your Honor, NCCIW was not licensed as a drug treatment center in 2019. Instead, the reason they were authorized, some of the physicians that were authorized to provide opioid replacement medication to pregnant inmates was to treat their pregnancy, because removal of that, discontinuation of that medication during pregnancy led to a high risk of fetal loss. So the provision of treatment during pregnancy was related to treating the pregnancy. Once inmates were no longer pregnant, the facility, NCCIW, did not have licensing or prescribing authority to treat opioid use disorder. Now, I will point out, Your Honor, that in the plaintiff's briefing, they rely on a number of sources that post-date the facts that gave rise to this claim. So in 2024, SAMHSA says, yes, this is the standard of care. In 2025, there's a US DOJ article that says this is the only type of treatment that we recommend for opioid use disorder. But the ADA does not require defendants to see into the future and understand what is going to be commonly accepted in 2024, 2025, 5, 6 years later after the incidents took place. In 2019, we had compelling reasons not to provide MOUD to non-pregnant inmates. So in addition to the licensure and prescribing authorities, we had a serious issue.
Sorry to interrupt you, Ms. McHenry. So I hear you saying that the reason why the treatment could not be provided was there weren't qualified staff, a lack of resources, essentially, is what you're saying. Is there a case that says that that's a viable reason in this context to deny a claim that alleges an ADA violation and or deliberate indifference? The prison simply can't provide the treatment because it lacks the resources to do that.
A number of cases, Your Honor, would stand for the proposition that prisons, in particular Richardson, are not required to offer any service that is, the specific medical care that a patient requests. But in addition to those licensure and prescribing limitations I talked about, we have serious issues of diversion, which were common in the carceral setting, as evidenced by at least 2 incidents in this record where the plaintiff diverted opioid replacement medications while incarcerated at NCCIW. On JA 3408, plaintiff admitted that she bought Suboxone from another inmate, and on page 3246, there's a note that she was caught hiding Suboxone in her bra during a search. So, like in Richardson, we have to keep in mind that context matters, that the ADA does not require prisons to employ any and all means to make specific services available to patients in their custody, nor does the ADA require prisons to create new programs or initiate new services that are, at that time, not available to non-pregnant offenders, simply because that's plaintiff's preferred treatment. And even the Smith v. Aroostook, which is a district court decision that plaintiff relies on, acknowledge this reality. On page 151 of that decision, the district court explained that there's only a limited number of facilities in the United States that have programs in place to routinely provide this medication to inmates. And the reason for this, the district court relied on the plaintiff's expert in coming to this conclusion that in 2019, opioid replacement medications were seen as drugs, not medicine. And that opioid replacement medications were sought after contraband in correctional facilities, and that it did not make sense to introduce these drugs into the carceral setting. There are other cases, Cartagena, Horton, that I think would also support the defendants, that absolutely do support the defendant's position that plaintiff simply did not qualify for continued MOUD after she was no longer pregnant. But I do, with my remaining time, want to make sure that I get to the 8th Amendment claims that plaintiff has raised as well. With respect to her 8th Amendment claim about discontinuation of MOUD, she has to demonstrate that defendants acted with deliberate indifference. That is, that defendants consciously disregarded an objectively serious risk of harm. And the plaintiff simply has not met this high bar that the 8th Amendment requires.
Well, you made it sort of easy in this case, didn't you? You gave no individualized assessment in terms of stopping it. And that's one thing. You just did it. You're not pregnant, you don't get it. You didn't say, well, we looked at this case in here, we think that this. That's kind of deliberately indifference where, you can almost turn your head and say, okay, you're no longer pregnant, let's flip the switch, you don't get it. Isn't that the same thing? That's the essence of indifference is, isn't it?
I would disagree, Your Honor. Well, I would perhaps agree with your characterization, but I disagree with the
My
plaintiff's
characterization?
characterization.
Oh, I see.
I apologize.
No, that's fine.
No, Your Honor, what I'm.
But it's not a characterization. I think that's a pretty good denotative definition of indifference, the lack of making a difference. And that's what it is saying. Look, you're no longer pregnant, you don't get it. That's my saying. Isn't that the height of indifference? Period. Without saying, well, you're still in postpartum, doesn't matter, or you still deal with that. That's a lot of chemical changes for a woman, I never had a child, but I have 3 girls, thank God, born and experiencing that. There's a lot of difference in terms of what goes on in chemistry makeup, and we find out more and more about postpartum and those things that are very important. And this to say, no, if you're no longer pregnant, you don't get it. Why is that not indifference?
Because while plaintiff didn't receive the treatment that she desired, or even the treatment that she says.
She not desire, she needed. Not desire. Desire some more. Well, I take this one. That's opioid addiction. Our country is just serious. I mean, it's just ravishing. It's just documented in books and reference journals. This is not a matter of what she desired. It was like she was trying to get a multiple choice. It's what she needed. And I don't think you can dispute that, do you? The opioid addiction existed and didn't stop when she no longer was pregnant, right? You agree with that?
That's right.
All right.
Your Honor, I think that where we diverge is that in 2019, we didn't have a safe or even we didn't have authority, the legal authority to offer the specific medical care that she requested, which was MOUD. Now, today we've talked about, and in plaintiff's briefing, they talk about the standard of care, which we can now maybe accept that that is the standard of care for somebody with opioid use disorder. But the standard of care does not mean that it's the only acceptable care that you can use to treat a particular patient. The standard of care is a tool that clinicians use
But
when
isn't
they
that
are assessing.
Isn't it counterintuitive to say it, that, well, the very drug that caused your addiction, that's what I'm going to give you to treat you? Oxycodone, those kind of drugs.
Well, oxycodone is an opioid agonist, and the reason that was given is because they have prescribing authority for oxycodone. They did not have prescribing authority for Suboxone, which was the
You didn't lose your prescribing authority for the MOUD after she was no longer pregnant, did you?
Yes, that's correct. That's correct. They did not have licensing authority to prescribe MOUD to non-pregnant patients because they were not a drug treatment center.
And who dictated that?
The DEA and the North Carolina Department of Health and Human Services.
The DEA said that you couldn't give MOUD to a person who still needed it.
They were
Well,
not.
That's in the record, right?
Yes, Your
Right.
Honor.
Right. And it said you cannot do this. You had to lock it up. So in other words, if you had no pregnant inmates, then what do? You just throw all that away or just don't
At
get
the
it?
time, those individuals would be tapered off of opioid medications. Now, I want to draw a distinction here to compare what the facts we have here with an example like Bronner v. Scott, which was in the Sixth Circuit. It was a 2021 case where the inmate came in with 3 prescriptions, one of which was for MOUD. There 2 others were not related. She was denied all 3 of those prescriptions upon intake, and she suffered roughly 30 seizures. She was hospitalized, and they still never gave her any of her medications, nor did they develop an alternative treatment plan. That's what deliberate indifference looks like. Here, we have a different situation. They were limitations on the provision of MOUD in the carceral setting. They did not send her to her cell to suffer withdrawal alone. She was put in the Robin unit, which is the sort of in-house medical unit within NCCIW. She was offered a tapered dose of opioid medication where every 3 days it was reduced. She was supervised 24/7 by medical staff. Her symptoms as they presented were treated. This is all in the record. It's not that. That's where I think we disagree on deliberate indifference. It may not have been the care that she would have received out in the community, but within the parameters of what NCCIW could do at the time, the defendants did not act with deliberate indifference. They did not act with a conscious disregard of a known risk to harm.
Well, let's talk about the shackling then.
Yes.
Isn't it obvious in open that shackling a pregnant woman would be, that there may be some constitutional deficiencies there?
Today, sitting here, Your Honor, I think we are living in a different reality than in 2019.
Well, I mean, it's interesting because everyone's talking about 2019, but I think it's 2018. Even in your, if you look at JA 513, even in your standard operating procedures, when it discusses offender restraints, and this was issued in February of 19, in the SOP, it says that restraints should be basically used on all offenders except, and it goes to, I think that's .1802B3, pregnant offenders in active labor, right?
Correct, Your Honor.
So that's 2018. Then in February 2019, April of 2019, Ms. Witherspoon has a conversation with the regional manager regarding shackling pregnant women. And then in November 22nd of 2019, there's this directive, this email a directive comes out, and then there's an email from Witherspoon basically acknowledging the directive, which she emails Thornton. I think she was on leave or something, regarding the directive regarding shackling pregnant women. And then on November 23rd, Ms. Thornton sends an email to the OICs, I assume those are the officers in charge, and says, once again, you have this discussion about shackling pregnant inmates. And then Ms. Edwards in December is transported to the hospital at UNC Chapel Hill. She's shackled. I think there's evidence in the record that says she was shackled at some point during her contractions. She's taken to the hospital for inducement, correct?
That's correct, Your Honor.
And so they induce her, and she's shackled during the, while she's having contractions,
She does allege that, yes, Your Honor.
which would be active labor, right?
Yes, active labor under the policy is defined as the onset of contractions.
All right. And so I just don't understand how that's not obviously constitutional deficient based on as far back as February of 2019. All of these different policies are saying you cannot shackle a pregnant woman, even during active labor, in transportation, in the last trimester. How is that not obviously constitutionally deficient? And I'm asking about Thorpe is the real reason why I'm asking you that.
Thorpe v. Clark.
Yes, in terms of deliberate indifference.
Sure. Chief Judge, I see that my time is up. May I respond to Judge Benjamin's question?
Absolutely.
Thank you. In Thorpe, there's an important distinction procedurally. In Thorpe, this court found that the dismissal of the Eighth Amendment claim was improper because we were at the 12B6 stage. We're now, I think it's critical that we're now at the summary judgment stage. We have a full record that's been developed. We're not just looking at the plaintiff's allegations that we accept as true. However, here on summary judgment, we have, the plaintiff has pointed, has emphasized issues with the policies, right? And that there's some perhaps inconsistencies between state policy and NCCIW's policy. I'd argue on the one hand that some of the citations to the NCCIW policy look at the use of restraints on all offenders versus the modifications that are there for pregnant offenders. But even putting that aside, it's well established that a policy violation does not equate to a constitutional violation. The district court correctly found that defendants.
But for purposes of deliberate indifference, under the Eighth Amendment, they're on notice. The question is, did she know what they were doing was wrong, right?
Did they consciously disregard a known risk of harm? Yes, that's the question.
All right, and so here, we have all of these policies, emails from Witherspoon to other staff members, conversations. I'm not sure how did she get around the knowledge portion of that.
Ultimately, Your Honor, I think what we have to remember is that all of these policies and each of the defendant's individual acts, every correctional officer involved in this case and any time they're in a correctional facility, is to balance individual dignity with community safety. So anytime they're removing an inmate from the secure confines of the correctional facility and taking them out into a non-secure facility, like a courtroom or like a hospital, they have to balance safety and the general requirement that we have to prevent escape, we have to prevent harm, we have to protect the inmate themselves. Also,
was there any evidence in the record of her that you all were concerned regarding her risk of harm or escape?
There's no evidence in the record that with this particular plaintiff we had that harm. But Your Honor, the point I'm trying to make is that the defendants here are constantly battling with that tension, and that they're trying to balance that individual dignity for the plaintiff and the requirement that they keep both inmates and all the staff, especially when they're outside of the secure correctional facility.
Yes, because the policy
safe.
says that is one
Yeah.
of the things that you all have to consider
Mhm.
in determining if there is a risk of escape or risk of harm. So that's why I asked the question, was there any determination that she was at risk of hurting herself or someone else, or escaping during the transportation while she's in the hospital, that would lead you all to shackle her during active labor?
There's nothing in the record that indicates that, Your Honor. If I may just conclude with one statement, I know I'm far past my
Go ahead.
time here. Thank you.
Go ahead.
The plaintiff cannot point to a single decision in this circuit or by the United States Supreme Court showing that an inmate has a constitutional right to be free of restraints when outside the confines of a secure facility, even pregnant inmates. And so in this case, the district court was correct in granting summary judgment on qualified immunity grounds for the defendants. Defendants respectfully ask that you affirm the lower court's decision. Thank you very much.
All right. Thank you, counsel. Mr. Longman?
May it please the court, a few points in rebuttal. First, defendants point to a number of fact issues here, but that's entirely the point, is that there are genuine issues of material fact. For example, they point to the alleged lack of authorization to be able to provide MOUD after Ms. Edwards gave birth. Now, we allege, and we have shown evidence that the citations that they're pointing to are citations about methadone, which is not the medication that she was on. The regulations were about, the facility was allowed to prescribe buprenorphine because they had, it's undisputed, they had ex-wayward providers on staff, which is what was required to be able to dispense and prescribe buprenorphine in 2019. They also ignore that if they couldn't have provided it in-house, they could have taken her off-site to be able to receive her medication for opioid use disorder, like they did for 6 months. It was only a few days that they provided MOUD in-house, which they did do in December of 2019. Secondly, they allege issues with safety. And the safety incidents that they point to happened after she was already taken off of MOUD. And this court in Cinto allowed a Eighth Amendment claim to move forward to a trial where there were alleged safety concerns with an individual who was diabetic and was denied insulin because of threatening behavior. So that is not a total defense to someone's rights under the Eighth Amendment and the Americans with Disabilities Act.
Can I ask you, you've indicated, I think, you've made a good point about there being fact issues here that might preclude summary judgment. But is there a case that suggests that a prison that lacks the resources sufficient to adequately constitutionally treat an inmate, that's a free pass for the facility if they say and throw up their hands and say they just can't provide that treatment?
No, Your Honor, and time again, this court has found that administrative barriers are not an excuse for deficient medical care under the Constitution. And this court in Gordon and Delonta 1 and 2 rejected those administrative barriers as valid defenses to liability under the Eighth Amendment. I see my time's expiring. If I could make one point about the qualification criteria under the ADA. Ms. Edwards it's undisputed, was qualified for the program, service, or activity of prison medical care. And that's the appropriate lens to analyze her claim. And this court, defendants say that she was not qualified because the policy itself excludes her, as long as she's not pregnant, from receiving MOUD. But as Chief Judge Diaz's questions go to, that reasoning is circular, and this court in Limon warned against analyzing what the program service reactivity is in a way that empties discrimination statutes of meaning, and that by defining the program at a level of generality that doesn't allow for the discrimination to be heard by the court, that's error. And for those reasons, we ask that this court reverse.
All right, thank you very much. We have one more, Ms. Kadar. Yep.
Thank you, Your Honor. A few points in rebuttal. So first, I'd like to just remind the court here that it's the defendant's burden to establish that the right at issue is not clearly established. That is, it's not the plaintiff's burden to show that the right is clearly established, and that's laid out by this court in the decision in Stanton. So even if that were not the case, there is a mountain of authority, a clear consensus between the courts, the prison policy, and third-party organizations condemning the practice of shackling around childbirth. So we contend the right is very clearly established. There's no contrary indication in the record. The defendants have pointed to nothing else. Two, there is no safety or security issue here. The defendants don't dispute that she was no security or flight risk. You can find that at JA 117 and 3057. That was an undisputed fact on summary judgment. Third, the principles in Thorpe, they apply beyond the motion to dismiss stage. This court has made it very clear. If there is still a question as to the officer's state of mind, even if that's on summary judgment, and even if that's after trial, the qualified immunity question cannot be decided until that's clarified. So in Coleman and in Fowler, that was on summary judgment where those Thorpe principles applied. In the Younger case, after a jury trial. And finally, that there is still a factual issue that needs to be determined. As to the officers, there's a real question of fact on the state of mind. Their sworn testimony as to their policies doesn't make sense. There's no security risk. And it's up to a jury to determine what they believed when they applied the shackles to her swollen ankles and when she could not get up to care for her crying infant. And in the words of the Sixth Circuit in Villegas, the jury's responsibility for weighing conflicting evidence is especially crucial where the ultimate issue is one that draws upon community values. And we submit that that is exactly the case here and respectfully request that this court reverse the decision granting summary judgment below. Thank you.
Thank you very much, counsel. I want to thank all of the counsel this still morning, I guess, for their fine arguments before the court. My colleagues will come down and greet you, and I also want to thank the cadets from VMI for being here with us this morning. I regret that I can't meet with you personally or online, but I understand my colleagues are going to meet with you after we conference the cases. So we will adjourn, and my colleagues will come down and greet counsel, and then we'll come back and conference our cases, and then the judges Benjamin and Gregory will come down and speak with the cadets after we're done. So thank you very much, Madam Clerk.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.